name's Jane and I work in the charities team specialising in employment. Going to be talking about essentially the TUPE application within the TR project within the ISPA. I wanted to mainly focus on TUPE because I think it's something that sort of petrifies people. They hear the word, they don't know what it means, they don't know what impact it'll have, and people kind of put their hands up. So clearly in 15, 20 minutes I'm not going to be able to make you an expert, notwithstanding it would put me out of a job, but I am going to try and raise the issues so that you can have a sort of meaningful discussion within the organisation to see where it applies to you. I think these are probably the key questions that you would be asking from the outset. And I think really the important points I want to flag is, firstly, TUPE is one of the most fact-specific areas of law that I work in, that I know about. And I think it's one of those ones that you might be seeking further advice and help on, because it's really only when the contracts start to come into play that you're going to be seeing how it interacts in practice. So, we've got the helpline, I know that there's recourse for further advice. You might find that this is one of the areas where you need to do that. And I think the second key point to flag is that TUPE operates regardless of any assurances you get. So if you have a tier 1 saying to you, you know what, TUPE definitely applies, we've got advice, you can rely on that. You can. It will apply regardless. You can't contract out of TUPE. All you can do is try and assess the liabilities that will flow from it and deal with that in the contract. So, that's really important from the outset, because if there's a difference in size of organisations, there's a difference in negotiation stances. You can't rely on what anybody tells you. You need to form your own view. If we're looking at the first question, what is TUPE? I'm sure many of you have had experience with it, so I'm not going to teach you to suck eggs, good or bad. Happy to discuss after the talk. But its very most basic principle, it applies where one service is stopped being provided by a service provider and a new service provider provides it. Where that happens, employees transfer. Sounds very simple, it gets very, very complex. But in this case, what we're really looking at, I understand it, that the CRCs will employ the individuals who used to work for the probation trusts, and you're going to be bidding for those services. It will also apply where smaller organisations provide those services as well. So you're not only looking at potentially probation trust staff or ex-probation trust staff, but also other organisations that have staff that are running those services. What happens if TUPE applies? Individuals transfer on the same terms and conditions, so that's salary, contractual benefits, pension terms with a couple of exceptions which I'll deal with, but also you really have to bear in mind that if it is probation trust staff that are transferring, they're likely to be on very good terms. That's a cost that you need to take into account if TUPE does apply. Fundamentally, you can't dismiss because of the transfer, I'm sure you know that. But even if the CRC or the previous organisation dismiss individuals, you're not necessarily off scot-free. That might be that you're liable in those circumstances, so you need to be aware of any dismissals that happen around the transfer kind of period, essentially. Next point, you essentially treat them as if they'd always be employed by you, so this is the risky part. The employees come across with claims and liabilities that are inherent, and if you don't deal with that in the contract, they will come across to you. It's also the case that the continuity of service transfers, i.e. how long they've been employed. So if they've already been employed for 2 years by the previous employer, you will inherit that 2 years. Why is that important? Because unfair dismissal applies where individuals have been employed for more than 2 years. So it's worth bearing that in mind as well. You have to talk to them. This is my broad way of describing information consultation, which are words that everybody really enjoys hearing. In terms of TUPE, you essentially inform and consult with staff representatives. So it's worth knowing whether there's a union involved, whether there's already staff representatives. And this applies whether you're going for the contract now or whether you're retendering in 3 years' time. So this kind of applies to you as a current employer and potentially ex-employer. What do you have to tell them? Broadly, that there's a transfer and essentially how it will affect them. TUPE is very much centred around the employees. It's there for protection. It's a very European concept. It's very protectionist. So it's very much focused about how the transfer will affect the individuals. You have to consult if there's what we call measures, essentially changes to their contract. You will be the one who's deciding measures if you're applying or if you're bidding for a new service. So how is that service going to be provided? What does that mean potentially about the individuals who are coming to you? When do you have to tell them this? In good time before the transfer is how it's phrased. In practice, that means you have to look at what effect your changes will have on the individuals and structure it accordingly. You've got to factor in time for potential consultations with redundancies, if that's going to be the case. You know, is there going to be a parallel consultation period for redundancy as well as TUPE consultation? If you've got more than 20 employees involved in this, you might be looking at collective consultation, and these are all things to bear in mind at the outset. When does TUPE apply? Unfortunately, I can't give you a list of when TUPE applies. I'd love to be able to do that. But what I did want to do is give you, these are the simplest ways that I think about where TUPE applies. When I'm looking at a structure, when I'm looking at an organisation, this is how I think about it. First and foremost, you'd be looking at whether the activities are the same. So what the CRC provides now, what you'll provide, and is that essentially the same? It may be very obvious, most likely it won't be very obvious, so it's important to drill down into it. I think it's probably easiest to think about it in terms of an example. If we took that the CRC provides employment training, and you're bidding for a new contract, which will provide employment training, but you consider it's got a much more holistic approach. It's a service that's broader than just employment training, there's other services that come along there. You may find that the CRC, the Tier 1, will push back and say that's not the same service, or it is the same service. And it's up to you to form an argument to say, is this the same activity, is it not, based on whether TUPE will apply. Although I say that TUPE applies regardless of any assurances, it is important that you try and come to an agreement in principle with the other organisation, because then you can look at trying to form a view on whether employees will come across and how you structure accordingly. So I think this is where I emphasise the fact that it's very fact specific, and if you do find yourself in a position where you're getting pushback one way or another, and it's vital to the organisation, you should be seeking further advice on whether you can put forward an argument that TUPE does or doesn't apply. The second point I've got here, organised grouping. In TUPE, everybody sort of loves the percentage rule. Oh, they spend 50% of time, they don't spend 50% of time, they come across, they don't come across. I'd encourage you to take a step back, because what essentially you have to look at with an organised grouping is whether the individuals are dedicated to that activity. How do you work that out? Well, if you look at, for example, if a CRC provides ex-offender services, including one service which might be drug rehabilitation, and you bid for a contract which only provides the drug rehabilitation, you're looking at employees who maybe work half of their time on the drug rehabilitation and half on their time on the other services. And the CRC is saying to you, well, they spend half their time, so they're not going to come across, or they are going to come across. What you need to look at is whether those individual people are structured with reference to that drug rehabilitation service. So before you look at how long they spend on it, you say, well, look, do they spend one whole day working on that, or is it just so happens that because there's more work in that area, they work on that? So this is just one of the arguments that you might come across where people say, yes, they work 50% on their time on that service, but that's just by happenstance. They're not organised to do it that way. So it's just one of the arguments that you kind of have to think about. How are these people structured in the service? You can push back and say, can you please explain how these people are done? Can you please break down that time? Can you say how you believe TUPE applies? The assignment point is essentially the percentage. So if you can say that there's an organised grouping, i.e. this group of people are dedicated to that service, do they then spend most of their time doing that? That's where the percentage comes in. That's where the assignment point comes in to say whether they are going to transfer. Why do I care if TUPE applies? Risk. What a lovely broad term for it. But and I don't mean to scaremonger, but I think TUPE is one of those areas that, because inherently there's so much uncertainty about where it applies, there is a huge amount of risk. Essentially, if, as I say, there's any dismissals around the transfer, that potentially could be your issue to deal with. Redundancy is potentially a fair reason for dismissal, as I'm sure you will know, but it still has to be done properly. And so even though you've kind of assessed, you've made redundancies, there still might be an issue there about liability. Discrimination, if, for example, there's a huge discriminatory practice that goes on in the employees that are transferring, if that's not dealt with under the ISPA, that liability comes to you and you've potentially got employment tribunal claims on your hand. Discrimination is uncapped liability, so it can potentially be very, very expensive. Failure to inform and consult is also a risk, so if you don't go through the process that I described, it's up to 13 weeks' pay. That is a joint and several liability between the organisations, but again, it's something you can deal with in terms of the ISPA, but you should be aware of that as a risk. I think also wanted to flag as well that speculative claims are a concern. So even if you're certain that you're not the employer, you don't have responsibility, it may be that the individual brings a claim with you because they believe that you're the one that's responsible. There's still cost involved in defending that claim and seeking that advice, etc. And practically speaking, you will probably want to contact your insurer and find out in what circumstances you might be covered if you had a cheeky claim brought against you. And quite often insurers require that you contact them before you make dismissals. It's just worth being aware of that if you are entering into these scenarios. Okay, so how do I deal with it in the ISPA? We've obviously mentioned that there's a lot of risk involved. And I think the main point is to say, obviously there's going to be a different bargaining power or negotiating power on behalf of the organisations. And you can't rely on the assurances. But kind of as James said, I think the ISPA is very much a jumping off point. In terms of employment particularly, you want to be making sure that you negotiate the terms and not taking it as read and not just signing on the dotted line without forcing the CRC or the Tier 1 organisation to give you further information. The indemnity that's set out in the guidance that you would put in is really broad and essentially mainly covers yes, TUPE faults. So if TUPE, if one organisation doesn't adhere to their TUPE requirements, then you would receive, an indemnity for that. But I would flag that that doesn't necessarily cover, for example, people that you weren't expecting to come across. You have to deal with that as an individual organisation. Practically speaking, think about whether TUPE applies. As I said, try and agree that. If you can reach agreement, can you ask for a list of employees that you understand will come across? Will the outgoing contractor, will the CRC, will they provide an indemnity if that list turns out to be misunderstood or if people come across that you weren't expecting and redundancies need to be made? So figure out whether they're prepared to provide that. Even if they don't provide the indemnity, it forces them to come up with thinking about who's coming across. And that in itself can be a helpful exercise, asking for that list, discussing that list, having a negotiation, as I say, putting forward those arguments about whether TUPE applies. And then I think David and James both mentioned when you're looking at the contract, you have to be thinking about the exit provisions, you have to be thinking about when that contract will be retendered. It certainly wouldn't be automatic that everybody who came across under TUPE the first time round will leave. What happens in those circumstances? Will you be able to seek recourse for redundancy costs? Maybe unlikely, but you have to factor it into the costs. If that's where you're going to be, you may be left with staff at the end that you don't need under new contracts. You may also want to try and agree warranties. All a warranty is a statement that a fact's correct, so it's certainly not as effective as an indemnity, but you may be able to get the other organisation to use them to essentially flush out the information you need. So a list of employees that they understand will come across. You also want to be asking for anything like self-employed contractors or consultants or agency workers, mainly because there's potentially a risk that they might be employees. As I'm sure you'll know, yes, you can say on the face of it that somebody's self-employed, but if in practice they're an employee, there's a risk that they might come across to you as well. You also want to be asking for information about trade union recognition and any recent disciplinary or grievance actions that might have caused issues that you might be responsible for. Yes.
a very obvious question here. What I'm not clear about is, if you're on tier 2 or tier 3, how much of all this responsibility rests with you, not the tier 1?
Yeah.
And then accessing this information from the CRC would have to be before the 1st of April, because you need it early in order to know your costings or your potential costings in order to bid. So would the CRC normally disclose this sort of information to you? Is it reasonable, as a potential tenderer, you'd want that information?
I think my understanding of how it would operate is that if you're putting together your proposal and you're putting forward the bid, you then put it on the basis of how you'd run the organisation, or you'd say, these are the services, who do you understand operates, or who do you understand works within those services. Your question about the CRC, my understanding is that they will be the employer, but the way of thinking about TUPE is that they stick to the services. So if the tier 1 never provides the services themselves, if they immediately outsource those activities, the tier 1 won't be the employer. So that's what you're looking at, who's doing it now, who's doing it then. But I agree there's an issue about having to know the information before you make those structures. But I think it's about structuring how you would do it and the services that you understand are being how they are being done now, how you want to do them, and then asking for the information. But it's difficult because we don't have any examples of contracts yet. But
I know, and I think our advice would be to ask for as much information as you can. Tier 1s may not have all that information to give you yet, so it's quite difficult to get it quantified. But it is something you need to bear in mind in terms of the risk, and do ask the questions. It is difficult. We really want to give you the message to go and ask, not to take things at face value, but to go and ask lots of questions. How much they will give you back and how much they know is harder to do when everything's being done at the same time.
So do you mean ask tier 1 or you go to the CRC's? That's what you want to be then.
I think I would suggest asking the tier 1s to begin with. It's difficult because the CRCs don't yet exist.
No.
The tier 1s don't necessarily know what they're getting, and it's a massive issue between them and the government about what's going to be handed over to them in terms of their liabilities. So it's hard to do in the face of all that, but I think it's reasonable to be asking those questions.
Do you want to add anything to that?
Yes, I mean, the good news is if you're providing a new innovative service that's never been offered before, no TUPE. But as soon as you think this is a direct replacement of or a successor to an existing service being produced by someone else, either another voluntary sector organisation who's lost their contract, or it was provided within NOMS, much worse probably, then you have to start looking at this very carefully. And to be frank, some large tier 1s or primes very carefully design services to look like they're new in order to avoid the risks and problems of TUPE.
Can I just ask a question for you? We were talking in the break about the issue where 2 probation trusts, so this lady works for Surrey and is running something, and there's a similar organisation in Kent, which was our example that we were talking about the other day. But about, because it may not be TUPE just from the CRCs as well. There may be
so I mean that exactly at this point. The way I understand it runs just now is the probation trusts either undertake the services themselves or they contract with another voluntary service organisation to provide those services. So essentially, when you're providing it, you're not just looking at whether the CRC does it. You're also looking at whether the other organisations do, and you may receive individuals from both of those organisations. So it's kind of wider net than just within the TR programme. I think that there will be potential implications.
So could I just ask, what happens in a situation if you're a voluntary sector, you're not contracted by the probation service, you've got independent funding, and tier 1 comes in and brings in a new service provider to deliver what you're currently delivering? Are your staff then potentially come into the pot for the TUPE?
There is potential. Yeah, if you really go back to the basic, it's where one service is stopped being undertaken and is undertaken by someone else. So if you lose your funding because the tier 1 is recontracting service, it may be that your staff will be in the ambit of TUPE if those services are being taken on the same, etc. So yes,
Not just charitable funding, if you're charitably funded.
if the funding is from a different area and you're going to continue the services as they were being continued, it's essentially there to protect so that the employees, if someone else is doing it, they'll move. But if you're receiving funding and you're carrying on the services in the same way that you always have, and the impact of a new Tier 1 contract wouldn't affect that, not necessarily any reason, because the employees will continue to have a job, they'll continue to work for you. So there's not a risk of a transfer there.
Yeah, that grant funding is drying up significantly because the Tier 1s are now, it's now being seen as statutory provision.
I think
I think that's right.
I think,
yeah, there's a
and
risk.
we've got the TR helpline. If people want to give us phone us and talk to us about examples, we're really happy to talk to them. I've got.
Yeah, we're almost there. I have one more slide and it's very quick.
Can I just hold off for you guys for one more until we get to the end, and then we'll
Let's
take
do
very quick questions.
It really is just pensions. It's much more of a flagging issue because, again, it will be very fact-specific in your circumstances. But the main point to say here is that if there are ex-probation trust act, i.e. public pension scheme, people who have access to a public pension scheme, if you are providing that, you may well be involved in the fair deal policy. The new fair deal policy will be where organisations actually have to become a participating member as an employer so that the employees retain access to that public sector scheme. So that's just worth bearing in mind. And broadly, pension provisions transfer. So if employees are entitled to receive a contribution, then you have to mirror that unless it's an occupational pension scheme. That has a statutory meaning. You can check that with your service providers, but it's just being aware of the issues in terms of pension schemes. That there's further information on that. Pensions is definitely dull, so I'm not going to go into it anymore. But yeah, there are some details in there. And happy to take up questions if we've got any time.
Very quick questions. Let's go to the back first then. If you could just shout so we don't...
Don't worry, I can. Okay, there are a certain group of workers, shall we say, that work in norms that are a little bit iffy at the moment of whether they are an employee or whether they're self-employed. Now, norms should know better. They should know the difference between self-employed and employee, but unfortunately they don't. Is there going to be any sort of protection for the new privatised companies to when they're taking on these workers? There might be a future dispute.
I mean, broadly, I understand it. No, that it within the contract. So I think that's a case of you having to establish the status of the individuals that are coming across. There's always a risk with self-employed contractors, and that's something that exists out with of this whole process. So again, that's probably one of those pieces of information that you're really, really wanting to go into be flesh out. What are the terms on which those people are providing those services, and not relying on them saying they're self-employed, and really making your own decision about that is probably what you need to do.
Okay, thank you. And one last question. Richard, yes, go, Lisa.
Hi, would I be right in saying that responsibility to TUPE rests with the Tier 1 and it only flows through to us if they put it in the contract? Because I can't see where it said it in the ISPA.
It doesn't say in the ISPA, that's the point. I think I'd say no. I'd say you really need to form your own view. If they don't raise it, you need to be raising it, I think, because there's so many areas where it might apply that you want to be raising it from the outset and trying to establish.
Because they do talk about subcontractor personnel.
Yes.
Like in clause 2, but no mention or reference to
TUPE. No, but the subcontractor personnel section is your staff, that's how you regulate your staff. But the TUPE section, the employee schedule is probably where you would be putting in information about TUPE applying. But if they don't mention it, I certainly wouldn't take it as read that TUPE doesn't apply, but maybe there's other things to say on that.
There's some issues in the explanatory guide about TUPE, and certainly there's the intention that people are very transparent about what is going to happen with TUPE, but legally that doesn't protect you.
And can I just make an observation? Will people be transferred from probation to CRC? then when the CRC is purchased by the Tier 1, they'll TUPE again to the Tier 1.
Depending on whether services.
Okay, because CRC is a company, they're transferred from probation into the CRC, and then the Tier 1 buys the CRC, so they acquire the company, and I suspect this is to enable the Ministry of Justice to transfer it on again by requiring them to pass on the company. So there's no TUPE when Tier 1 takes over. They may take over as owners of the company, but that's not a TUPE situation. And just to come back on your other issue, TUPE applies regardless of what the paperwork says. If there is a transfer of a business or an activity or a change of contract that fits within the definitions, even if nobody thought about it, the staff transfer and there's nothing you can do about it. We've had situations where someone's taken on a contract and the day they started operating, 5 people turned up on the door and said, we're TUPE transferred. And they said, we've never heard of you. It made no difference to the fact that these people were becoming the employees of that voluntary organisation because TUPE applied regardless of what the paperwork said.
Is there a time limit in which you can make that claim?
There's a 3-month time limit from whenever the offence essentially happens, but I'd be very wary of giving you direct timeframes with TUPE because any changes you make, it can be linked back to the TUPE happening. So you can't, for example, say, great, 3 months has passed, so now we can perform a redundancy exercise and we're safe. If it's still because of the transfer that you're making those changes, you're still at risk. So there really isn't a time frame that I can say anything around or because of the transfer may be raised.
From an employee's perspective, can that employee claim 6 to 9 months on that they've now realised that that post is in existence, that they should have been TUPE across to?
It really depends on the facts and those. They've got 3 months from a claim, but where the claim arises from, I can't give you a distinct reason for that. It's quite a broad, very complex area. Definitely get advice if you're in that situation where you might have that as an issue.
My staff are a contract that's taken place.
Okay, the helpline to help.
Thanks.
Thank you
very much.
very much.